Okay, well, we're going to go ahead and get started. Want to thank everybody for signing on this morning to attend our second review this week of the newly signed into law AB685 and SB1159, which was signed by Governor Newsom last week on September the 17th. We're hoping that you will get some out of this presentation today. We're going to cover the highlights and what's going to really be impacting and what we need to do as employers immediately. There are going to be three presenters today. We're going to have myself and Marianne Romero. Marianne is our senior claims work comp advocate for Relation and Pan American Insurance Services. She is out of our Sacramento office. We have Mr. Dan Castillo, who is Vice President of our Loss Control Department, which will cover AB 685. And I am Joe Dunn. I'm the Claim Services Manager for Relation Insurance Services and Pan American, and I am housed here in the Fresno location. With that, this presentation is being recorded, and the link will be provided to everybody at the end of this presentation. Hopefully this one takes, because the recording on Tuesday didn't take very well, so hopefully today's will get better. So without further ado, Mr. Dan Castillo, let me get that up. AB 685.
Thank you very much, Joe, and welcome all, and happy Friday. And it's been a unique 2020 year here, but hopefully we'll all get through this together as employers, and we're here to assist in any way we can to our policyholders as well. But anyway, so this AB 685, and then the assembly, they got together and they decided we need a better way in order to start enforcing some of this infractions, if you will, from the COVID-19 infections among the workplace, and to track outbreaks, and also to put programs, procedures, best practices in place in order to prevent more outbreaks, if you will, and try to control this COVID-19 infection at the workplace and so forth. There's a couple issues. There's intertwine between the Labor Department and also CalOSHA. CalOSHA is the enforcement arm, but the other agencies like the Labor Department, if you will, and also the CDC from the federal side, and also the local health departments, they could relate this information to OSHA, and OSHA, California Occupational Safety and Health. CalOSHA could go to the employer's location and start monitoring, looking, investigating, and determine if best practices are in place at the employer's site to protect the employees from this infection. Okay, so next slide, please. So some of the provisions and so forth. This is all stemming from the Injury and Illness Prevention Program, and CalOSHA has requested that all employers, that they have a supplementary program or a program embedded into their Injury and Illness Prevention Program. Okay, some of the requirements on this COVID-19, especially the Assembly Bill 685, is provide information and notice to employees and subcontractors or anybody who has connection to that employer or that work site, okay? Regarding the infections that arose from the work site, and it has to be communicated in writing and also provided to all affected employees, if you will, of that employer, okay? And also if it's the employer, if it's represented by labor or labor union, I should say, they have to be provided to the designated individuals of that labor force or that labor union as well, okay? Also, with this, the employer must provide in writing and communicate to all employees the benefits that an employee can receive if that employee is infected by the COVID-19 virus and they cannot come to work. And that means the 80 hours of sick leave. That means unemployment benefits, that means any other benefits that's offered by the state or federal, just like disability, for the federal or local benefits as well. Also, they would also provide information as to that employee's PTO time, the paid time off time as well. So that's important, as the employee has that information available to them. Okay. Subcontractors, representative, all the employees and any subcontractors who come in contact with that employer, they must have an opportunity to look at that employer's prevention plan, if you will. And this is why it's important that all employers have a written prevention plan. How to prevent the COVID-19 from entering the workplace. And that would mean, and some employers are doing this, temperature checks. And again, the temperature is 1.4, not 104, 1.4 and above indicates a potential fever or a fever, and that's under the guidelines of CDC. Sanitations, training of the employee as well. So anything best practices put forth by the CDC or the local health department, they want the employer to start implementing that and put it into a plan where it's written, and follow that plan, and then demonstrate that plan and those procedures to the employee or the representative or subcontractors that that employer has a specific plan to prevent an outbreak from occurring. Okay. Next slide. All right, so here's the issue with this, the citation, alleged violation, and the serious. Now, the Department of Labor, the Department of Licensing, and then again, this is intertwined with the different agencies, if you will. But again, the Cal OSHA is the enforcement branch from the Labor Department, from the Federal Labor Department, and also from the State Labor Department, also from the Licensing Board. The issue is when they're putting this information together, the Senate bill, and it's intertwined with the other Senate bill that Joe's going to talk about, they want to do a better job of tracking infectious diseases or COVID-19 at the workplace. But again, training for employees and supervisors related to the prevention of employee exposure to the hazards or to similar hazards. And it's interesting. I had one document request sheet, which is when Cal OSHA goes in there, and when Cal OSHA makes a visit to an employer and they do their inspection and so forth, and then they request the documents, safety documents from the employer. This particular Cal OSHA enforcement officer asked the employer not only for training on the COVID-19, but also training for other issues, and they're allowed to do that. It's pertinent to what they're investigating. But valley fever, they had on the document sheet valley fever. Did you train your employees at valley fever? If so, please let me see those documentation. So this is not just the COVID, they're looking at other infectious diseases out there. Valley fever is one of them that's been existing here for quite some time. So I thought that was quite interesting. So at that point, obviously the employer did not have any documentation or on valley fever, did not do any training on valley fever. So we'll see where that's going to go. So, all right. Procedures for discovering and controlling access to the correct the hazard and similar. So again, emergency action plan, if you will, for an infection. If there's an infection on that site or a particular area, what are your procedures and process in order to combat that? Under the CDC, if that occurs in that area, they want you to leave it for 24 hours, come in and clean it with the appropriate cleaners, if you will, to disinfect that area and not come back into it for another 48 hours. But it all depends on the series of infection in that area, okay? And the other issue is the communication with the employees, and we talked about that on the health and safety, and that goes with the training of the COVID-19. How can you contract it? How can you protect yourself? What are signs and symptoms? What you should do if you contract it, don't come into work, for example. Make sure that you call your employer, go to the doctor, under the doctor's care and instructions, get tested, or the employer could ask you to go get tested if you have any signs and symptoms of the COVID, okay? And that's all very important as well. So we don't, if that one potential employee not say the source of infection was from the job site, but outside the job site, we don't want that employee to bring it into the job site, okay? Information that employer wishes to provide at any time before citations are issued. This is very interesting because under this AB685, COVID infection is considered to be a serious citation. Serious citation starts at $18,000. Usually it takes maybe 3 or 4 months, well, in order to issue a serious citations, because there's specific protocol that Cal OSHA has to go through on this matter. One of the protocols is a 15-day notice to the employer that the Cal OSHA or the division is going to be issuing a citation of a serious nature. Before they issue a citation of serious nature, they would send out a form called a 1BY form. And the 1BY form gives the employer an opportunity to tell or to rebuttal against the citation, basically. Under this AB685, in order to streamline this, they did away with that 1B1 form. They don't have to give, or they're not going to give the employer the opportunity to rebuttal or give their thoughts or give their reason why this should not be a serious citation. So that kind of streamlines this. And that portion of it is going to take into effect January 1st, 2021 until January 1st, 2023. So that's kind of an addendum to what the Cal OSHA procedures and protocols are for the issuing a serious citation. The other issue, it's considered an outbreak if you have 3 cases, not from the same household, in a 2-week period. If that's the case, you have 24 hours to report it, or 24 hours to report that this type of outbreak in order to Cal OSHA or the health department, okay? If Cal OSHA comes in and they see this to be an outbreak, and then they could issue an order of prohibiting use or a stop order for that job site or that location. In many cases, when they issue an order to stop, it's the whole company. What they're saying here, this could be this specific site if this is the site of the infection and so forth, just that site. So that's up to the Cal OSHA enforcement officer, okay, in order to determine if they're going to put a stop order. Once a stop order is placed, usually it's 1 or 2 or 3 days that you have an opportunity to go in front of a judge to say we did all this and we're doing all this in order to make this this site safe, particularly when it comes to COVID, and the judge could order to open the operation again. But again, the health department will have to get involved, and other agencies who need to get involved in order to issue that order to be reversed itself. Okay. So again, a lot of questions are coming up with employers, but I'm representing 4 of our employers on a COVID-19 social distancing serious citations. At this point, and it starts at $18,000, but after we talked about, because a 1BY form was given out and we discussed this, and I put the information on writing why this citation should not be existing or not be given. But they came back with a $5,800 fine on this thing. On one incident, we were able to reduce it to $2,200, I believe, with a non-emissions cost. But what I'm trying to say here is in those situations, and in those 4 citations that I'm dealing with separate employers, it's the shade. During the break time, the employer did not have enough shade for the employees to take a break where they're 6-foot distancing on the shade trailers or in the canopies. So that's one issue you want to take a look at. Another citation that we worked on, this was in early March, and this was in Nevada. The health department and also their OSHA department issue a $10,000 fine because co-workers were working together putting up a window. This was a construction site, and they didn't have their mask on. Okay. We're able to combat that, and the judge says this is at that point, the judge thought this was frivolous, and the judge threw it out. So we got out of that one. But again, they're starting to enforce these practices, if you will, on the face covering. when you can't have the separation during lunchtime. And again, because of the shade, there wasn't enough shade to separate all the employees of that crew with a 6-foot distancing while they were eating lunch. And obviously you can't wear any face covering when you're eating lunch, and they were exposing each other, if you will. And that's why Cal OSHA issued a citation of a serious nature that started at $18,000. We got it at $58,000, but again, we reduced it to $2,200 on that case. We haven't accepted that at that point. There's still some issues that we want to discuss with this. So with that, is there another slide, Joe?
Last one.
Yep. Last one, yeah. And this is what we kind of hit on this a little bit, but and again, this goes to affect the provisions that we just discussed here, especially on the noticing and so forth, on the serious citation. That's going to will remain in effect until January 1st, 2023. That means that provision is going to be dissolve itself at that point. But again, this is going to take an effect at the January 1st. What we just discussed here. But having said that, Cal OSHA could go in there because of the social distancing, not wearing the PPE, not having written program in place on the supplementary on the COVID program. They could issue citations. This citation would be a serious citations, and the penalties, as I mentioned, starts at $18,000 on this. If you need some assistance, have additional questions, please, you can contact myself or any of our loss control personnel or your producer, and they could get in contact with me. And I don't know if Joe has my number or my email address, and towards the end of the presentation, in order to get a hold of me, have any additional questions. There's a lot of good information on the Cal OSHA consultation website, and there's a section there on questions regarding COVID-19 and Assembly Bill 685 that's very helpful as well. Okay.
Thank you very much, Dan.
Thank you, Joe.
Thank you very much, Dan. A lot of great information on AB 685. We are now going to move into SB 1159. And with that, Marianne.
Hi, everybody. It's Marianne Romero with Pan American. How's everybody doing today? I'm going to be talking about COVID-19 in the Senate bill a little bit in regards to the governor's executive order, as well as some of the healthcare worker section. So let's start. So Senate Bill 1159, when does it expire? It'll in fact until January 1, 2023. It can be repealed, which basically means they can extend that if they want to. If they don't, it'll just expire. Just like it goes away basically. Senate Bill 1159 is not going to rescind or alter or amend any other work comp claims that have been already finalized, or it won't even allow it to reopen any work comp files if they've already been settled. So that's good news. So we don't have to worry about the claims that were happening in a March to July for them to be reopened. So that was good news. It did get passed on September 17th. I think that's a notable date that everybody's going to need to remember, because as we go through this presentation, there's going to be a 30-day time limit to report some claims that you're going to need to be aware of. We will get to that later, but just remember September 17th is going to be a date that you want to write down. It is an urgency statute, meaning it will go into effect immediately when it's signed. Normally we don't see the Senate bills or Assembly bills go into effect immediately. We normally see them give an effective date. Usually it's the following year. This time, because of the urgency of COVID-19 and the spread of it, causing the economy to take a downturn and businesses going shutting down, they did make it an urgency statute, which I think was probably the right move. Next slide, Joe. Okay, so here's some common things that you probably need to know. They're defining what an injury is, or an illness, or a death resulting from COVID-19. And they're saying all of those circumstances have to apply for a COVID-19 claim. And so they're saying that they have to test positive within 14 days for the date the employee performed labor for you at your place of employment at your direction. They're also defining place of employment that does not include the employee's residence. So if anybody is working from home, it's not going to be applicable to you. They're authorizing a year-long study of COVID-19 on the impact of workers' compensation. I honestly think that's a good idea, because what we're hearing on from different physicians that are commenting on our webinars, they're worried about the long-term effects. What we're hearing right now is some of the cases could end up with pulmonary fibrosis, which is basically scar tissues of the lung. That is a problem that they're concerned about. They're also concerned about heart problems coming out from COVID-19. That's what they're seeing. So they've ordered a study to see how that's going to work out. We'll see what comes out of it. They're also saying on or after March 19th, 2020, and on or before July 5th, updates apply retroactively to July 6, 2020, and last until January 1st, 2023. And the same rules apply for covering dates March 19th to July 5th. We'll go through that in a minute, and we'll be able to clarify it for you. Dates of injury, that they define that, which was so nice, because I think difficult going through this COVID-19 when it first hit, is nobody could figure out the date of injury. Was it the date of the exposure, the day they got tested? Nobody knew how to define that. And so they have defined it now, and they said the date of injury shall be the last date of the employee performed labor or services at your place of employment at your direction. So that cleared up some things that we were concerned about. And then obviously the diagnosis, this is actually changed as we go through the presentation, but they're saying it has to be a licensed physician and surgeon holding an MD or a DO degree, or a state licensed physician's assistant or nurse practitioner. That was interesting, because I don't know if some of my customers may be on the phone, but it was very hard. It was very hard. There was no doctors. They were all closed down. When we were down when it was really hitting in the desert, it was incredibly difficult to find a doctor to do it. Everybody was going to the emergency room. So I think this helps a little bit, because they were really pushing MPN network at the time, and it didn't help. So that's done. I'm so glad that they fixed that. Next slide, Joe. Benefits provided are going to be for all the benefits in workers' compensation on a normal claim. They're saying you're going to get full hospital, surgical, medical treatment, disability, death benefits, and that's good. So they're not taking away any benefit from you. But they're also saying that the Division of Industrial Relations, they are not going to be able to collect death benefits on a claim. So a normal claim, if you had somebody that died and there was no dependents, the money would actually go to the state. It would be $250,000. That's a hard pill to swallow. And so now they're basically saying, yeah, they're going to waive their rights. So I think that was in favor of the employer. Next slide. Any questions?
Any questions, please put them in the chat, and we will answer the questions at one of these sections through the chat, so we're focusing on the questions for each section.
Okay, we're good. I don't
Okay,
see so far.
we will move on. COVID-19 for firefighters, peace officers, and healthcare workers. So the rebuttable presumption.
¿Qué pasó, caballero? ¿Qué estás haciendo?
There were 3 specific
Hey.
new labor codes that were listed when the law went into effect. There was 32.12.86, 32.12.87, and 32.12.88. 32.12.87 specifically deals with healthcare workers, firefighters, frontline folks. So their injuries are presumed compensable unless facts are disputable and may be controverted by other evidence. Unless controverted, the appeals board is bound to find in accordance with the presumption, meaning all injuries, all COVID-19 cases are presumed compensable for these line of employees. It applies disputable presumption of workplace compensability until January 1st, 2023 for anyone infected with COVID-19 who works as a firefighter, peace officer, or a healthcare provider. The healthcare provider will also include employees who work like in a senior citizen care facility, things along those lines. Because even though there might not be an MD or a DO, there are LVNs that work in there that do provide, like licensed vocational nurses, physical therapists go into there. So those employees will be housed in that healthcare provider umbrella. With this particular section, there is only a 30-day delay window if there's any kind of dispute that this injury or the COVID-19 infection was not work-related. So we only have 30 days to delay that and investigate it, which normally in workers' comp, we have a 90-day delay window, but for this code section, we only have 30 days. So to qualify for the presumption, a workers must receive a positive PCR test, not the antibody test, for COVID-19 within 14 days of working at the place of employment on or after July 6, 2020, and within 14 days of their termination from employment. So if an employee is terminated, for example, today, September 25th, they would essentially have until Friday, October the 9th to test and test positive. If they test on Saturday, October the 10th, it's too late. They missed that 14-day window. If an employee has paid sick leave benefits specifically available in response to COVID-19, those benefits shall be used and exhausted before any temporary disability benefits or benefits under Labor Code 4850 are due and payable. Examples of COVID-19 pay would be the Families First Act or the work sector for employers over 500. That's the CARES Act that was signed by the federal law that expires on December 31st. So employees must use the Sick Leave Act pay before temporary disability benefits will kick in. If an employee does not have those sick leave benefits, the employee shall be provided temporary disability benefits per Labor Code 4850 from the date of the injury forward. There is no 3-day waiting period for COVID-19 cases. Temporary disability starts the very first day they miss work. Unlike for COVID-19 related cases before July 6th, there is no requirement for employees to be recertified for temporary disability benefits every 15 days for the first 45 days for COVID-19. They just need to test positive, and then they got to test again, like in 45 days. But with prior to July 6th, they would have to test every 2 weeks to continually certify to be off of work for temporary disability benefits. An employee has to have a positive test to qualify. So you need to determine how many employees you have at the time of reporting. If you have less than 500 employees at the time of reporting, please determine if the employee is entitled to the 2 weeks of sick leave pay under the Families First Act. Workers' comp administrators will not pay for lost time benefits unless this benefit is exhausted first. If you have over 500 employees, the employee may not qualify for the Family First Act. So we just need to make sure that we review for any other emergency act that could apply. Essentially with SB1159 now, he's capturing everybody for sick leave pay. We do need to obtain a certification of diagnosis and testing date from the provider. This needs to include or should include the name of the physician, address, phone number, and certification of diagnosis. So what this is saying is that we have to have the documentation to support that the employee tested positive. We just can't take his word for it. We can't say, oh, I tested positive. That doesn't work. We need the actual documentation to support it so that you can have that documentation so you can pay them, and then you have that also for your taxes at the end of your policy year or the calendar year for your taxes, for your tax credit. Qualifying reasons to take emergency paid sick leave. An employee is entitled to take leave under the EPSLA if the employee is unable to work or telework because the employee is subject to federal, state, or local quarantine or is an isolation order related to COVID-19, has been advised by a healthcare provider to self-quarantine due to concerns related to COVID-19, or has experienced COVID-19 symptoms and is seeking a medical diagnosis, is caring for an individual subject to federal, state, or local quarantine or isolation order related to COVID, or has been advised by a healthcare provider to self-quarantine due to concerns related to COVID, is caring for his or her child whose school or place of care is closed due to COVID, is experienced any other substantially similar condition specified by the U.S. Department of Health or Human Services. But with all of these, we need documentation to support it. Employee just can't say, oh, my daycare is closed, I'm off for the next 2 weeks. They should be able to get a letter from that daycare facility saying we are closed currently because of COVID-19, we can't open. And then your employee can give that to you and say, well, until I can find a new daycare, I got to stay home with my child, so forth. So with all of this, we still need the documentation to support while you're paying them the 2 weeks of the sick leave pay. Any questions on this section?
Yeah, you got a couple questions in the chat, Joe.
Okay, can employers request a written letter from a physician or EPSLA or FCRA, and we won't need that anyways to claim it our work comp carrier? Well, you need that letter in order to pay them for the sick leave pay, but you still need to report it to your work comp carrier, whether it's work related or not. And Marianne's going to cover that in the next section. We need to report all positive COVID-19 cases for all of your employees, whether it's work related or it's not work related, but you need the documentation to support why you're paying them, how much you paid them, because you will utilize that letter to for your taxes at the end of the year for your tax credit. Okay, if employees were paid COVID benefit checks in May and June due to the qualifying for these benefits, again, if tested positive, no, they only get the benefit once. So it doesn't matter if it's March 16th through July 6th or July 6th forward. They only get the Care Sick Leave Act once. That's it. And it expires December the 31st. If an employee responds yes to any of the COVID-19 screening questions, are they eligible to get paid under the Sick Leave COVID Act? Yes, they are, and you will have the documentation to support that. What if they have family members who cares for their child and they claim they don't have that luxury anymore? How do we verify this? That's a very good question.
Yeah, it might
I don't
be one
have
of
an
those
answer.
questions.
I don't have an answer for you at this very moment in regards to that. If you want to reach out to me afterwards, I will research that, but I don't know the answer to that right at this very second. What action items should a small employer, 4 or 5 total employees, take if they had an employee test positive for COVID-19 back in April and has not returned to work? The employer has continued to pay normal wages until the end of September. they're a hobby equine farm with no reporting, no claim has been reported to work comp carrier. Hey Gus, call me afterwards. We can discuss this one because if they have only 4 or 5 employees, they're not going to qualify for to be considered an outbreak. But there's more to this than just. Let's connect with that afterwards. Okay, and with that, we're going to move on to the next slide, which is Marianne.
All right, back to more good stuff that will happen for Senate Bill 1159. This is for all other employers. So this is your section if you're on the ag side, you're not a healthcare worker, you're not a peace officer, you're not a firefighter. This is where everybody, I think, on the telephone conference will likely land. And so let's go through this because this is going to be an important piece. I think what the governor did was he basically looked at, I really don't want to cover everybody, you know, for every single COVID claim. I just want to make sure we don't have any outbreaks in order to keep the economy going and keep businesses open. And so that, I think, really was his objective. And so he made an outbreak definition as part of the Senate bill. And so this outbreak definition qualifies for any COVID claims on or after July 6, 2020, okay? So in order to meet the outbreak definition, you have to test positive for COVID at the employer's place of employment who has an employer that has 5 or more employees, okay? So now they're giving you a definition, 5 or more employees. You have to test positive within 14 days after they perform labor at your place of employment at the employer's direction, on or after July 6th. Employees test positive during the period of an outbreak at the employee's specific place of employment. Examples are buildings, store facilities, ag fields where he or she performs work at the employer's direction. So the specific place of employment is not the home of a resident unless he or she provides home health care services to another individual at his home or residence. I have no idea why they put that in there. It doesn't make sense to me, but there it is. The date of injury shall be the last date the employee performed labor, which is something we went over previously. You know, they defined what a date of injury is, which was very helpful. The place of specific place of employment we're going to get to because there's a lot of questions that go on over what's really a specific place of an employment when you're in the ag business, and we will hit that in a minute. So stay tuned. Next slide. An outbreak exists for the purposes of 3212.88, which is where you guys follow for if anybody's on the phone other than healthcare workers. If within 14 calendar days, one of these occurs at a specific place of employment. 4 employees test positive for COVID-19 at a specific place of employment with 100 employees or fewer. So they're defining, you know, how many employees you have in the field, okay? Or if you have more than 100 employees, they're saying 4% of the number of employees that test positive for COVID-19 were more than 100 employees reported to a specific place of employment. So those things you really are going to have to know what the outbreak definition is because it's going to drive a lot of COVID claims, what you have to report on certain forms. So make sure you take note of that. The place of employment, there's the definition, okay, is ordered to close due to a risk of an infection with a COVID-19 by a local public health department, the state department, Division of Occupational Safety and Health, or school superintendent. So they're saying, okay, you know, it's got to be at the specific place of employment. They're giving you the definition of the outbreak. You know, if you have less than 100 employees, 4 people test positive, you're going to meet the outbreak definition. If it's 4% over 100 employees, you're going to meet the outbreak definition. They're also saying you're going to meet the outbreak definition if you're ordered to close, which makes sense. If an employee performs in multiple places of employment within 14 days of his or her positive test, the positive test must be counted for the purposes of determining the outbreak definition. That's what it says. If an outbreak exists at any one of them, that is the employee-specific place of employment. So I would give an example as irrigators. If you have irrigators that are moving from different fields, you're going to have to take a look at that to see where they've been in order to determine the outbreak definition at each location. If all the conditions are met, the injury or death related to COVID is presumed to arise out of or in the course of employment. In other words, if you meet all the definitions of the outbreak, it's considered a compensable claim. Temporary disability. Again, it's going to lead to, basically all the other pieces of the Senate bill. It's going to say you have to use up all of the families first or the worker sector's benefits or any other benefits that are applied specifically to COVID. You have to actually use those benefits first before temporary disability is paid. If there's no sick leave benefits available, then temporary disability shall be paid. So if there's people that have already exhausted those benefits, they're going to get temporary disability. There is no waiting period, which is very different from a normal workers' compensation claim. A normal work comp claim that's outside of COVID, you have a 3-day waiting period. They're waiving that. They're saying they get it right away. So unlike for COVID-19 claims before July 6th, there was no requirement for employees to be certified for temporary disability every 15 days for the first 45 days following COVID. So it doesn't look like they put that in place for the Senate bill, which is good. I think that's because of the shortage of tests, believe it or not. I think that's where they were looking at that. Supplemental paid sick leave for food sector workers, workers that are covered if they meet the following criteria. Work for an employer with 500 or more employees nationwide and qualify as a food sector worker, which means that they either perform work in a certain food-related industry or in the retail food supply chain, including pickup, delivery, warehousing, packaging, retail, and preparation. Perform work outside the worker's home and are exempt as critical infrastructure workers from any statewide stay-at-home order. The workers do not have to be classified by hiring entity as an employee in order to be covered. Examples of covered workers are going to be farm workers, grocery store workers, food pickup, and delivery workers. That's typically what's paid. Subject to federal and state local quarantine or isolation orders, they're going to be able to qualify for the benefit. If they've been advised by a healthcare provider isolate due to COVID-19 concerns, they're going to qualify. They're prohibited from working by the worker's hiring entity due to health concerns related to the potential transmission of COVID-19. So that means if you have a shutdown, they're probably going to qualify. Next slide. The next piece on the Senate bill for an outbreak delay period is they're saying they actually give you 45 days versus 30 here, which is nice for all other businesses. I think that will give you enough time to do your contact tracing, get your claims reported, and then the carrier can determine compensability. The only way they can rebut the 45-day compensability rule is if they find evidence that's discovered after the 45-day period. But I will tell you, I've sat on some webinars the last day, the last few days, and the applicant attorneys are really going to fight you on it. From what I'm hearing, they are really going to make sure you stick to the 45-day compensability. So my recommendation is, get the claim in as soon as you can so we could start the process, because they are just chomping at the bit to overturn that. And so, Joe, I'm going to let you take the presumption slide and go from there.
Okay. So the presumption is disputable and may be controverted by other evidence unless controverted and appeals board is bound to find in accordance with the presumption. Extends to employees following termination of services for a period of 14 days, commencing the last date they actually worked. The evidence is relevant to controverting the presumption may include evidence of measured in place and reduced potential transmission of COVID in the place of employment. Evidence of employees' non-occupational risks of COVID-19 infection. So we do have the right as the employer to ask the employee where they think they contracted it. in order to determine whether it's not if it's work related or not. The next slide is, for questions, and then we kind of get into the claims reporting and tracking piece, which I'll cover too. We do have a question here: is do we report all confirmed cases to our work comp carrier or only work-related cases? You have to report any and all positive COVID-19 cases to your work comp carrier effective July 6th forward. And you have 30 days from the date the order was signed in order to get all of those positive cases reported to your carrier, whether they are work-related or not. How you determine if it's work-related or if it's not work-related, there is a traceability questionnaire that we have created here at Pan American Relation that we're happy to share with you, that you can ask your employees specific questions to determine whether they contracted it at work or they contracted it elsewhere. We do have the right to ask those questions, and we will get into more of that in the next section. But yes, you have to report all of your questions, all of the positive COVID-19 cases from July 6th forward. That's what the order reads. For the cases from March 19th through July the 6th, they want that data as well, but the order is specific to July the 6th forward, but they want the data prior to July the 6th as well. Okay, so we will move into the claims administrator reporting and tracking. All COVID-19 claims, when an employer knows or reasonably should know that the employee has tested positive for COVID, the employer shall report to the claims administrator in writing via electronic mail, facsimile, within 3 days. Now, when they put in their shall on the law, that basically means you must. For the purposes of reporting, the employer shall not provide any personal identifying information who tested positive for COVID-19 unless the employee asserts that the infection is work-related and has filed a claim. So anybody who has tested positive for COVID-19, you're going to have two separate documents. Two separate forms. One, non-work related, and it's going to be completely anonymous. You're not going to list the employee's name. You're not going to have their social security number, driver's license number on it, anything other than like an employee number or a badge number, something that you as the employer can identify that employee with. The work comp carrier will have no idea who that person is and would not be able to trace who that person is. Because in that situation, HIPAA applies. Now, if the employee says they contracted it at work, well, now you're going to fill out a regular work comp claims form, the DWC-1, the 5020, and in that situation, HIPAA does not apply. And the employee's name's going to be on there, his date of birth, address, everything, just like a regular standard work comp situation. The date the employee tests positive, which is the date the specimen was collected for testing, that's the date of injury for these work-related for this section. The specific address or address of the employee's specific date of employment during the 14 days preceding the employee's last date of testing positive. So what they're saying here, the employee tested positive on Monday, September 21st. You need to find out every single location that that employee worked at going back to Monday, September the 17th. So the 14 days preceding that test date. Where did that employee work? If they worked at 14 different locations, you need to list 14 different locations on that non-industrial reporting form. And then you need to list the highest number of employees who worked at that employee's specific location of employment in the last 45 days preceding the last date that they worked. So what was the total number of employees that you had working at that specific location with that employee within the last 45 days? The employer is aware an employee is tested positive on or after July the 6th and shall report all data requiring to their claims administrator within 30 business days. So basically, that is saying you have the law was signed in on September the 17th. You essentially have until October the 17th to get all of your non-industrial claims reported to your work comp carrier. The employer shall report the highest number of employees who reported to each work at each of the employee's specific places of employment on any given day between July 6th and the effective date of this section, which was September 17th. The claims administrators must use the information to determine if an outbreak has occurred for the purposes of administering a claim. The claims administrator must also continually evaluate each claim to determine whether the requisite number of positive tests have occurred during the surrounding 14-day period to determine if an outbreak has taken place, which Mary Ann touched on earlier. The if you have 4 employees test positive, if you have under 100 employees, but greater than 5 employees, or if you have over 100 employees, it's 4% of your employee staff testing positive, which we can clarify that a little bit more in a second. An employer or persons acting on behalf of the employer who intentionally files false or misleading information or fails to submit information when reporting is subject to a civil penalty up to $10,000. The Labor Commissioner may issue a citation following inspection or an investigation. We understand that some of these situations and some of these citations are going to be given, and they're going to be challenged, and and employers are going to fight these, which is the employer's right, not a problem. And these will be fought in superior court, not like through Cal OSHA. These are done in the superior court, and this will get challenged. Now, I have heard from some employers that they're just going to pay the $10,000 penalty because that's nothing to them. They don't really care. They're just going to pay the $10,000. They're not going to report, and they don't really care. Okay, you have the right as an employer to do that. It is our position that you don't do that, because the subsequent issues that is going to take place down the road is that you're going to get the employer is going to get the citation for $10,000. They're going to go in the parking lot. They're going to call Cal OSHA. Cal OSHA is now going to come, and they are going to go through everything with a fine-tooth comb. And as Dan was mentioning earlier about some of the citations we're seeing, you know, $58,000, $85,000, $100,000 fines. Now you've got the $10,000 fine or penalty from the Labor Commissioner. Now you've got an $85,000 fine from Cal OSHA. So it is our recommendation that for the next 30 days, somebody just start plugging away at those and get those all reported to your work comp carrier on a non-industrial basis to avoid any kind of civil penalty, and then to avoid Cal OSHA just making a surprise visit, because we do know that they will work in concert with each other in order to get this data. The other piece is about the 4 employees greater than 100 and whatnot. We have, what I have on the screen here is a sample of the non-industrial reporting form, which we're happy to share. But if you have 5 employees, if you have greater than 5 employees but less than 100, you need to have 4 employees test positive to constitute an outbreak. You have greater than 100 employees, you only need 4% of your staff to test positive. A question that we have received recently is, you have a huge vineyard, and this vineyard is 50 acres, and you've got 5 different crews, 1 crew on every 10-acre section, and each crew is 50 employees. So you have 500 employees at the lot. Only one particular group of employees has tested positive for COVID-19. So let's say you have 10 employees in field number 1 or vineyard number 1 on this 50-acre parcel. You have 50 employees there, 10 of them test positive. So if you think you meet the definition of an outbreak, well, technically you don't, because you have 500 employees in that location. The law says at location. It doesn't say at location, but broken down by crew or broken down by parcel in the vineyard or broken down by parcel in the broccoli field. It's at that location. And if that location is 50 acres, it's a 50-acre location. And that actually works in your benefit. Because instead of having the definition of an outbreak for that one crew and having to send the whole crew home for the next 2 weeks, you have 500 employees working at that location, but only 5 employees tested positive. You're under that 4% threshold. So the only people that go home for the next 2 weeks are those employees that tested positive. They go home. Everybody else can continue to work. So we want to have that greater number of employees to offset that 4% ratio. That is in your benefit. And we do have the non-industrial claims reporting form. You can see it is completely anonymous, doesn't have any identifying information other than an identification number. And we are happy to share these documents with everybody. And questions, we do have a question. When does reporting need to be done to Cal OSHA? Is that also required unless it's deemed not work related? If it's not work related, you do not need to notify Cal OSHA. You need to notify Cal OSHA if the employee is hospitalized for greater than 8 hours. They're actually admitted to the hospital. They're not just there for observation purposes. So the standard Cal OSHA reporting applies. You don't need to report non-industrial claims to Cal OSHA. The only thing that you do need to do for every single positive COVID-19 case that's considered work-related, you don't need to notify Cal OSHA if it's a standard person sick and out for a couple of weeks, but you do need to list it on your 300 and 300A logs because they are reportable. Okay, if I have an employee call me today and say he's tested positive, I have to go back 14 days from today to see where he worked, notify the claims adjuster or claims administrator where he worked for all of those days. That is correct. That's correct. Are we going to be provided the forms? Yes, Betty, we will get the forms out to everybody. Are we liable to report if employee was placed under quarantine by a medical professional, but the test was not administered? You have a report from a medical professional quarantining that employee, whether or not the employee has tested or not. You have a medical professional quarantining that employee. You are obligated to pay that employee the 2 weeks of sick leave pay and then report it to your industrial carrier. We don't know if it's work-related or not work-related. In this situation, I would say non-industrial and report that non-industrial because your pay that you're paying that employee needs to match what your payroll report is going to be, what you do to your work comp carrier for auditing purposes. So it all needs to line up. So yes, you would need to report that on your non-industrial reporting form. We are considered an essential business at grocery store, and the CDC has specific guidelines for those employees, for those workers do be able to continue to work. Does this change the protocol? I don't believe that it changes the protocol from the CDC because the CDC provides the main guidelines. The new regulations are indicating that if the employee is being quarantined and is tested positive and needs to stay home, then the CDC is going to back that up. But if you have specific guidelines from the CDC, you need to follow those. So the emergency leave includes administrative employees as well who don't work in the field. That's correct. and it's for everybody. So if the employee is an administrative employee and he's working in the office doing payroll, HR, and things like that, then yes, that employee, those employees are also entitled to the 2 weeks of sick leave pay. Okay. That does conclude our presentation for today. If there are any additional questions, please feel free to let us know. Everybody should have our email address and contact information because you've received the invitation. Any additional questions, please feel free to reach out. And we will, this is being recorded. We will get this recording sent out, and we will provide the non-industrial claims reporting form, and we will also provide a traceability questionnaire that you can ask your employees where they think they contracted it. And we'll also provide the executive summary and then a side-by-side comparison. Marianne created a very nice side-by-side comparison delineating between what is the essential employees and what is everybody else. And you can compare how each labor code is applicable. So with that, I'd like to thank everybody for attending today, and we will get this out. Let's see. Do have another question. If the business uses one address but has two different buildings that employees work in, do we treat that as one separate location? If you have let's say you have 5 buildings, but all buildings are considered one location because they are separated by a parking lot or corridors, but it's all considered one location. That is considered one location, and that would be, you would have to count the total number of employees that are at that location. So if you have 5 buildings, you're going to count all the employees in all 5 of those buildings. Yes, everybody will get a copy of the slides. What if the employer places you out and the test comes back negative? Are we obligated to pay the employee is still symptomatic? Regular sick leave pay, because now it's just regular sick leave pay, but it's not going to be COVID-19. So if the employee tests negative, it's just regular sick leave. It's not COVID-19. So you just treat that like anything else. 2 quick questions. Are work comp carriers sending out and notifying their policyholders about these claims as well? Yes, they are. Every single insurance carrier in the state so far that I have seen, they are sending out notifications to their policyholders. With some carriers are having online non-industrial reporting that you can do. Some are sending out forms that you can email in or fax in. And some are doing, the call-ins. So each individual carrier is kind of doing their own thing, but it's all the same data. And we have created a form that you can utilize as well that would meet the same thing that you can fax in or email in. On the 500 employee count, how is that determined, especially with the seasonal variations in employees count? It's the total number of employees that you have at that time of exposure. So if you have 750 employees that are on your payroll, when that employee tests positive, that's the number you use. Then the season ends, now you've only got 20 employees, then you'd only use 20 employees. So it's how many employees you have at that time. If an employee tests negative but is still required by a public health department to quarantine for 10 days, aren't they eligible for the California sick leave? Yes, because you have a medical professional quarantining them and you have the medical documentation to support it. So yes. Okay. Well, thank you everybody again. And please feel free to reach out with any additional questions. No, one last question. If we are using an FLC combined with our labor, are they considered a part of our employees? Only your employees that report directly to you. If you have 3 different FLCs, our understanding is it's your employees, because you can have another FLC working in a different area. That's our understanding, but I can reach out to get additional information on that. But our understanding is right now it's the employees that are on your payroll.